Conn matter, case D 10-427302D. Counsel, your appearances, please.
Good afternoon, Your Honor. Michelle Roberts, bar number 9168, on behalf of the plaintiff, Danielle Conn, now known as Danielle Scaggs.
Good afternoon, Your Honor. Roger Giuliani, bar number 5967 for the defendant, Devin Conn, present in court as well, appearing in an unbundled capacity.
All right. Mr. Giuliani, did you, something filed on your client's behalf?
Did I file something?
Yeah.
Well, he had filed an opposition and counter motion on March 12th. And then I believe,
A reply was
Yeah.
filed to that.
Unfortunately, I missed that in my review, so if you briefly want to argue the opposition and counter motion.
okay, Your Honor. So, Your Honor, my client, the defendant, has had visitation with the minor child every Friday from 4 o'clock to Sunday at 8 p.m. He's been very integrally involved with the child in his life. He's continued this timeshare, plus he's had some additional time as well. Currently, we're in a situation here, based on their request for relocation, that we do not believe that that would be in the best interest of the child. We believe that it would substantially hinder Dad's rights in this case. And additionally, the closeness of Devin and the minor child is very important. All of Devin's family is here, his extended family is here. Dad coaches his basketball team, and he has frequent and continuous contact with the child each week. So with that, we're asking that their motion to relocate be denied. In response to their reply and their motion with regard to his criminal record, yes, he's had some issues with the law, and that was dealt with in modifying the party's custody order in October 2012. Since then, he's been a good, involved father and shouldn't be denied his custodial time based on mom's decision to relocate. We also question the length of the relationship that mom's had with her husband. Obviously, everyone has the right to marry, and I hope they live a long, happy life. But the reality is that he's been overseas for most of the time, and so the child doesn't have as close as a relationship with the stepfather as they make out in their paper. So,
Your client has filed a counter motion seeking primary physical custody?
No, I mean, he's counter motioning to keep things the same. He's counter motioning to deny their motion to relocate. So if she wants to relocate, then yes, he would like primary physical custody to stay here. If her choice is to relocate, then the child should stay here.
Mr. Roberts, your reply.
Well, my client has had primary physical custody since 2012. In our reply, we stated that the day that we filed our motion was also the day that Mr. Conn was arrested for domestic violence for assaulting his girlfriend. Unfortunately, we don't have the incident report number. In our reply, we requested that you have Mr. Conn turn over that incident report. There was an arraignment this morning in that matter. We don't know what the outcome of that was.
Mr. Giuliani, was your client arrested for domestic violence?
He was arrested. At this point, there are only allegations, but he was arrested, yes.
Did he have an arraignment this morning?
Yes, sir.
He did. I'm not representing him in the criminal part, but
Enter a plea?
No. Court date was moved to April 28th.
And there was no plea entered?
No, sir.
Were charges filed, do you know?
No, sir.
You didn't receive a criminal complaint?
Yes, I did.
And the complaint charges you with battery domestic violence?
Yes, sir.
You remember if it was a first offense, second offense, third offense?
First offense?
All right, so what's your next date to go back to court?
April 28th.
And what court is that in?
Today it was
Justice.
in 10.
Las Vegas Justice Court,
Yes, Justice
Municipal
Court.
Court?
Justice Court, sir.
You know your case number?
Not offhand.
All right.
Your Honor, do you have a copy of my reply? Because I have the register of actions attached to it. Would you like?
I've got it here. Why?
Oh, the register of actions with the case number is
Okay.
attached.
Well, I thought you didn't have access to that information.
We don't
so-
have access to the police incident report as to what the allegations were. All we have was the register of actions.
Well, discovery is open. The court's going to set the matter for a evidentiary hearing date.
Now, you're on,
Has the burden in these matters to show that she has a legitimate good faith basis for the move. It appears to the court's satisfaction that her marriage to a serviceman who's been stationed is going to probably meet that burden. After that, she has to show the actual benefit to both her and the child. And the court will briefly review those Schwartz factors, and then the burden shifts to Dad. If she's able to meet her burdens and he fails to substantiate a legitimate good faith basis to deny the request, Mr. Giuliani, you need to make sure that your client is aware that he could be faced with a significant amount of attorney's fees. Likewise, Ms. Roberts, if your client is unable to meet her burden, she could be responsible for a significant amount of attorney's fees. How far out do you want me to put your evidentiary hearing?
actually, as soon as possible. I think we only need about, 45 days for discovery. So,
Well, I'm unbundled, so let's give him a little more time, so.
All right, give me a date.
July 20th, Your Honor, for staff one.
Okay, your trial date will be July 20th, 9 a.m. You're on a stacked calendar. That means that you might not start at 9, but you will have your trial on July 20th. You need to be here ready to go by 9. If you're not the first case called, you will remain in the hallway until you're called. Don't leave the area unless my marshal gives you a specific instruction on when to return. Because we go quickly and we're limiting this to 3 hours, that's 90 minutes each side. We require you to do certain things in order to facilitate that schedule. On or before July 13th, each side will be required to file a written pretrial memorandum containing specific proposed orders and specific proposed findings that you believe your evidence will support. Also due on or before July 13th are any and all evidentiary objections to the opponent's proposed documents and or exhibits. Those documents and exhibits must be exchanged by July 6th. All of those documents and exhibits must be bound, tabbed, and independently page numbered consistent with each other. Volumes will be exchanged between counsel or the parties, and your originals will be provided to the court clerk. All of those documents must have been previously disclosed either through 16.2 disclosures or formal discovery process. The deadline to have discovery completed will be June 29th. The court will require witness lists to be filed by May 11th. The witness list must be more specific than just facts and circumstances surrounding the parties. If I get 6 witnesses that all have the same thing on their witness list, I'll allow one of them to be called and the remainder will be excluded. If I have a witness who's going to show up and testify to something extraordinarily out of the ordinary and it's not somehow alluded to in the witness list, they will be excluded. Do everybody understand?
Yes, sir.
All right.
One other thing, is June 20th a Saturday?
Yes.
Okay. We're requesting at this time, I know that the weekends are Dad's time, but there is a wedding for my client's aunt that my client is requesting that she be allowed to have Dylan for that day and to
What
attend the
weekend?
wedding. June 20th. And
You can allow him make-up time when?
following Monday, he can have makeup time.
That's fine with my client, Your Honor.
All right. So we'll do that. We'll exchange the 20th for the following Monday. So is your client going to be living on base, or is she, or are they going to be living in the community?
My husband has already rented a house. in
Where, Ogden?
Clearfield.
Clearfield? All right.
Clinton, sorry, Clinton.
Huh?
Clinton, Utah, sorry.
Okay. Sir, if she's granted the permission to relocate, at a minimum, you're going to receive every spring break from school, the entire summer with the exception of the first week after school lets out and the week before school resumes. There's also something in Utah they call Utah Education Week. Back in the old days, we used to call it the deer hunt. because that's about the time that it falls. You'll be entitled to that break from school as well, as long as every other Thanksgiving and at least half of every Christmas break. In addition to those times, I understand that there is, I mean, it's not that far of a drive, and I could require the parties to meet in Beaver or someplace that's close to halfway. The court would afford you additional time on the weekends, especially if there's long weekends. So even if the court grants the move, I want you to understand, before you guys start digging in your heels and fighting over it, that the court's going to ensure that you get a significant amount of time, and she's the relocating party, so the court will put some of the burden on transportation on her. If that gives you leverage to help settle the case, then mission accomplished. That being said, that the court's not prejudging these cases. Just for your informational purposes, I want you to understand that at a minimum, the court would grant you at least that much visitation. All right.
Your Honor, are you making any findings today that mom has primary physical custody?
Well, yeah, I think that's the order. That's the current order, correct?
Correct.
So she has primary physical custody, and I think that's when I explained the burdens. That's, I mean, her burden is fairly clearly set out. I tend to look at,
I believe the October 25th, 2012 order has that right.
yeah, I like Flynn, which is a 2004 case, and Jones, that's a 94 case, but they spell them out pretty clearly about what her burden is and when the burden shifts.
Ron, just for purposes of when I talk to my client, if you were to allow for the relocation, would you allow for an offset for child support based on the cost of travel?
Yeah, absolutely. Nevada's the jurisdiction, it's the home state. If she moves, Nevada's still going to be the home state. Any future child custody actions will take place here, and as the moving party, she's going to be required to bear a portion, if not all of the travel expenses.
And it'll remain the home state as long as dad is living in
Yeah.
Nevada.
Yeah.
Are you ordering any child support?
And I'll order you both to buy stickers in Beaver that say, "I love Beaver." It's the greatest souvenir you can get in the state of Utah. I catch heat for my sticker all the time. All prior orders will remain in full force and effect at this point in time. You weren't anticipating moving before school year ended.
No, not until June. Well, she was anticipating June, but it's still summer, July 20th for the hearings.
Right. So anything else, counsel?
No, that was it, but my question was regarding the child support. Are you making any orders on that, or are you just going to defer that at this time?
Yeah. Was there a request to modify the child support?
Yes.
Yeah, I'm gonna defer on that right now, and we'll address that at the time of trial. The court will reserve jurisdiction to retroactively modify effective as of today's date. Anything else, Mr. Giuliani?
No, Your Honor.
No, and if we have any possibility of resolving this, obviously we'll submit stipulation and order.
Yeah. I mean, you've got the scheduling order and everything, and like I say, it's it could be a lot worse. I mean, there's no airport closer than Salt Lake, but Salt Lake's not too far from Hill, and the drive's not too bad. Do you like to ski?
Snowboard, yes.
Oh, okay, all right. Once again, the good places aren't up near Hill, but I'll make her meet you in Park City or at the mouth of Big Cottonwood or something if that's if it comes down to that. All right, good luck, folks. Appreciate your efforts, counsel.
Thank you. Permission to withdraw and bundle, Your Honor?
Yes, and Ms. Roberts, you'll prepare an order for me from today. All right. Good luck.